Today the speaker is R.Parthasarathy, Senior Advocate, and the topic is Suit for Land under Clause 12 of the letter patent. A few words about the speaker. He is son of Raghavan, who was also an advocate. Now he rarely comes to the court, I believe. Okay, very rarely he comes to the court. And our speaker, Parthasarathy, is a product of the legend Parasaran. I think it needs a clap. Originally, Parthasarathy, our speaker, joined the office of Mohan Parasaran, and he assisted Mohan Parasaran in the Vodafone case for the Union of India, that is against the Vodafone, both in Bombay and Honorable Supreme Court. In fact, even the latest in our High Court also, he has appeared in some of the cases and he has succeeded, but he said he did not want to say so many things about his judgments or the cases where he appeared. So with these few words, I pass on the message. Mike. In the latest designation by the High Court, he was designated as a senior advocate around 1 year back. On the behalf of the MBA, we congratulate him and pass on the mic for his speech. Thank you.
Thank you, Mr. President. Very warm welcome to all of you. I know it's 5 in the evening. The topic is quite heavy, and I'll try and wrap it up as soon as possible. But the words used in the invitation, MBA Academy in collaboration with Tamil Nadu Senior Advocates Forum are holding lecture series as part of the continuous learning process. That's interesting because of this lecture, I had to learn a lot. It's easy standing and arguing in court. Most judges will tell us that it's very easy to stand and argue in court, but to stand and deliver a lecture before an audience is a very painstaking task. You need preparation. You need to be prepared with what kind of questions will fly from there. And you also need to be concise. Just because the client is not paying me today, I'll be as concise as possible. Now the topic here is very, very interesting, personally for me, because I had spent a better part of COVID in researching on this topic. And this article of mine was ultimately published in the Law Weekly in February 2022. Now, a very brief introduction of what is a suit for land. Now, you all know that the Madras High Court, along with the Calcutta and Bombay courts, are the only 3 presidency courts vested with something called original jurisdiction. Now, original jurisdiction is the jurisdiction to try suits of various pecuniary limits. Now, why this jurisdiction to try suits? Because in these 3 presidency towns, Madras, Bombay and Calcutta, the East India Company set up its prisons mainly in order to control and take care of the interests of Englishmen staying within the limits of Fort St. George, Fort Williams and the Bombay jurisdiction. The East India Company thought it fit to codify something, to bring in some code, some law to govern these people, Englishmen and women who are amenable to their jurisdiction and properties amenable to their jurisdiction belonging to those Englishmen and women. Now, this was the situation since 1700. East India Company was there from 1700 till 1857 when the First War of Independence took place, and thereafter the Crown in England decided that we've had enough of East India Company because you people are running the Indian judiciary like it's your own backyard. We will step in, the Crown will step in, we'll enact laws, bring in codified laws for establishing high courts in India. Now, 1800 was when Supreme Courts of the 3 judicatures came in, Calcutta, Madras and Bombay. 1800s was when the Supreme Court came in, and 1862 was the High Court. Now, this letters patent was probably issued for the first time in 1862 for India. Previously, Supreme Court was under a charter. The three Supreme Courts were under charters issued by the king. Now, letters patent was probably the first time in India for establishing three high courts in India, Madras, Bombay and Calcutta. Now, while establishing those three high courts, the legislature in England thought that we must define the limits to which these courts should exercise jurisdiction, both over subject matter and over territories. Now, we are coming to the second part. Now, subject matter is one thing. Territories is also important. Now, you have something called the High Courts Jurisdiction Act, amended in 1957. We have territories over which High Court of Madras exercises jurisdiction, likewise Calcutta and Bombay. Now, it is not akin to Corporation of Chennai limits. Corporation of Chennai is a very vast limit. But High Court it exercises jurisdiction restricted to its territories defined under the Act, named under the Act. Now, therefore, when you have a jurisdiction conferred upon such high courts to exercise a right over a particular subject matter over a particular territory, you needed to be very precise. And that is when Clause 12 of the Letters Patent of 1862 initially and amended in 1865 came into force. Now, before I tell you what this Letters Patent is all about, a very brief idea about how naughty this subject has been since 1862. 1862 was when the High Court of Judicature's Act came into force in India. Three high courts were set up. 1862 was the first letters patent for all three presidencies, amended in 1865 for all three presidencies. But before that, what went on in the history of legislation, history of courts in India, and also why so much importance for suit for land. Now, what is land according to you? What do you understand by the word suit for land? Can any one of you just say what you understand by the word suit for land? A suit for immovable property. Suit for title. Okay. Anybody else? Suit for immovable property, suit for title. Anybody else who can contribute to the confusion? Because already there's a confusion of 150 years. So we can also contribute. Suit for ownership. Yes. Ownership, title, suit for immovable property. What about possession? For possession of immovable property. All right. Declaration of title. Okay. This is the broad understanding of everybody of what a suit for land is. A suit which primarily deals with title to immovable property. A suit which primarily deals with protecting possession of immovable property or getting possession of immovable property. Primarily. But then, if it was so easy, we wouldn't have been having 340 judgments on this aspect till now. Now, if it was so easy, I wouldn't be standing here. So, what went on in the mind of these judges before deciding this issue of what is a suit for land? Now, I'm not saying it, but I'll read out a particular excerpt of two very, very famous judges in the Indian judiciary. One is Justice S.R. Das. Now, interesting anecdote about S.R. Das. Justice S.R. Das is, he was initially elevated to the Calcutta High Court as a puisne judge. He then served as the Chief Justice of Punjab and Haryana for 2 years. And then he was one of the first judges from India to be appointed to the Federal Court. Have you all heard of the Federal Court? It was the predecessor to the Supreme Court of India. From 1937 till 1950, we had the Federal Court when Supreme Court was established in 1950. So Federal Court was the highest court in India, and appeals against Federal Court's judgment used to go to the Privy Council. So he was one of the first members of the Indian judiciary to be appointed judge of the Federal Court. And then he served as acting Chief Justice of India twice. And then he retired as a Chief Justice of India after serving as a chief for 3 years in 1959. A very, very checkered character. I must say, a brilliant man. Now, his words I'm using. This is what he said in a 1945 judgment sitting in Calcutta. The expression suit for land has given infinite trouble to judges who have had to construe it to arrive at its true meaning and import. A perusal of the cases reported in law reports. Now we are talking of 1945. We are talking of reports from 1862 to 1945. A perusal of cases reported in law reports will at once disclose a singular lack of uniformity in decisions. Indeed, the reader's mind is bound to be overpowered by the multitude and the subtlety of the distinctions between them. I shall therefore not take upon myself what I consider to be an impossible task of attempting to reconcile the numerous divergent and conflicting decisions and deduce any common principle therefrom. This is what he said in 1945. And later on, 15 years later, Justice P.B. Mukherjee, again of the Calcutta High Court, said this, and it's very interesting, this quote. Courts in India have been laboriously cultivating land in the field of Clause 12 of the letters patent of the Chartered High Courts. Long and deep are the judicial furrows, rich is the harvest. No judicial Ricardo has been able to discover any law of diminishing returns in this area. The crop of judicial decisions is abundant and varied to suit every legal taste. Now, you can't sum it better. Beautiful language. So basically what Justice P.B. Mukherjee was saying in 1965 was it's impossible to reconcile all these judgments. Now, thereafter, there was one celebrated case in 1950 rendered by the Federal Court, Mulji Jaita, which is often quoted in all Clause 12 letters patent cases. Now, what Justice Patanjali Shastri, a member of that bench, said was, the numerous cases in the books on construction of Clause 12 of the letters patent reveal a prodigious amount of judicial time that has been expended on endless debate as to its meaning and application. So, all of them were unanimous that it's impossible to reconcile the three views. The three views, I mean, the views from Madras, the views from Calcutta, and the views from Bombay. No other court had original jurisdiction then. So, we were concerned only with these three courts. Now, to understand why so much of confusion, even as on 1945, one has to delve slightly deeper into history to understand what was the jurisdiction exercised by courts in India, first of all, and secondly, courts in India vis-a-vis suits for land. Now, it is historical fact that East India Company started in 1612, but then once they started, they sort of established over a period of time a very, I would say, efficient justice administration system for the Englishmen, for the English people and their properties. Now, they had a series of charters from the 17th century which established judicial systems in Bombay, Madras and Calcutta. And importantly, what was amiss there was none of those people who were manning these judicial systems from the 1700s in these three presidencies were lawyers or judges. They were all men of commerce. So you can understand why this confusion started initially, right? Now, the natives in Madras, since the East India Company courts applied only to, had jurisdiction only extending to Englishmen and women and their properties, what about natives? What about the natives of Madras, Bombay and Calcutta? What law were they subject to? So, the natives in Madras had something called the Chowdhury courts, which adjudicated upon all their local disputes. In Calcutta, it was known as the Zamindar courts, and in Bombay, there was no special court designated for this. Now, however, all these systems of administration had one thing in common. East India Company, no lawyer or judge, laymen administering them. So, the confusion started there. Thereafter, what happens is when King George I came into reign, he issued a charter saying that enough of East India Company's jurisdiction extending to judicial tribunals. The English legislature will issue a charter. Now, the king will issue a charter. So, the first charter was issued in 1726 to establish something called the courts were very loosely worded as civil courts and criminal courts. In fact, the words used were Diwani Adalats and Faujdari Adalats for India. Diwani Adalats were civil courts, Faujdari Adalats were criminal courts. And appellate courts from these were Sadar Diwani Adalat, appellate court from civil jurisdiction, and Sadar Nizamat Adalat, appellate courts for criminal jurisdiction. So these were the courts established for locals, non-Englishmen and women and non-English properties. So this is how the system originally originated in 1700s. A codified, not a codified, a structured system of law in India. Previously it was totally unstructured. Each princely state had its own law. Each princely state had its own ruler. Nobody had a common codified or common structured tribunal or court. Now, as far as the Regulating Act of 1773, next feature is the Regulating Act of 1773. It gave the three presidency towns, that is Madras, Bombay and Calcutta, jurisdiction over various aspects of law, various aspects of rights, various aspects of properties. Now, 1773, the Regulating Act came in, but then it took another 25 years for the English legislature to realize that we can't do with this loose system. We need a more codified, better system. So, in 1800, they issued a charter to establish Supreme Courts in Calcutta, Madras and Bombay. Now, what is very important is the Supreme Court, so established in these three presidency towns, exercised something called chancery jurisdiction and equity jurisdiction. Very important for the purpose of understanding what clause 12 of the letters patent is. Now, chancery courts are all courts of equity. Chancery courts, they adjudged people based on equity. So were equity courts known as King's Bench. Whenever there was a queen, it was called Queen's Bench. Whenever there was a king, it was called King's Bench. So courts of chancery in England and courts of equity were the courts based on which the Supreme Court of Madras, Bombay and Calcutta were modelled. Now, why it is important is because courts of equity always exercise jurisdiction only over person, not a property. Now, that's a basic distinction which led to a lot of confusion. All courts of chancery and equity in England always exercised in personam jurisdiction. That is, jurisdiction over the physical person and not the properties belonging to that person. If a person had properties with him in that jurisdiction, well and good, we will exercise our jurisdiction there. But if properties are situated elsewhere, we will not exercise jurisdiction over those properties. We will exercise jurisdiction only on the person. So this jurisdiction called in personam jurisdiction was created by the English courts, by the chancery courts, by the courts of equity in England, the King's Bench and the Queen's Bench. And that is the jurisdiction which the Englishmen imported into India in the charter issued for establishing the three Supreme Courts. Now, if you see, the Supreme Court's jurisdiction was extended to all British subjects residing in Bengal, Bihar, Orissa, initially in Calcutta. So, Calcutta comprised Bengal, Bihar and Orissa. And then came Madras later, and then came Bombay. Three Supreme Courts were established. But as I said, what is important is the same jurisdiction which vested with courts of chancery and equity in England were vested with the courts, Supreme Courts in the three presidency towns. So what is that? That means in personam jurisdiction. So to understand the suit for land concept, you must also understand that courts initially would exercise jurisdiction over land only if the land was within their limits. But assuming A was within the limit of a court, but his land was elsewhere, the courts would still exercise jurisdiction over A, not the land, and tell A, you do this qua your land, you do that qua your land. So there was a distinction drawn between the courts of equity in England and the exercise of jurisdiction by them and suits for land basically. So when you import that into India, that led to a lot of confusion. Now, just for completion of facts and a matter of historical perspective and interest, the presidency of Madras, did you know, comprised of the whole of Andhra Pradesh, most of Madras, not the whole of Tamil Nadu, most of Tamil Nadu, parts of Kerala, parts of Karnataka, Telangana and Orissa. That was the presidency of Madras. And the Bombay presidency, interestingly, the whole of Gujarat, most of Maharashtra, because some of it was in the state of Mysore, and then Konkan, then northwestern Karnataka, Pakistan's Sindh province, and also Aden in Yemen. That was also subject to the jurisdiction of the Bombay Supreme Court. Now, Calcutta also, there was no limitation. See, all these three Supreme Court charters did not have any strict limitation on exercise of jurisdiction over land. They only said we will exercise jurisdiction over the person. If the person has land within our jurisdiction, we will take that. If the person doesn't have land within our jurisdiction, we will see whether we can issue a writ to that person to comply with whatever. If the person can comply, we will hold him for contempt or whatever. Supposing A is residing in Madras presidency. He sells his land in Kanchipuram to B. Now A is residing in Madras. The courts in Madras will have jurisdiction over him in person. He enters into a contract to sell a land to B in Kanchipuram. Now the courts will say that you are residing within our jurisdiction. We will exercise jurisdiction over you in person. We are not bothered about the land. You execute the contract, give it to him. If you don't, we'll hold you for contempt. If you don't, we'll file an execution against you. The land may be anywhere. So this was the confusion which originated in England, was carried forward in 1800s to Madras, Bombay and Calcutta by virtue of the charter for establishing the Supreme Courts of Judicature. Now this continued till 1857 when the first CPC came in. Now even before the CPC, what English courts have always held in chancery, in equity is, whenever there is something which we do qua an individual, the writ which we issue will be binding on that individual and we are not concerned with what the consequence of that is. So if an individual, as I said, is within the jurisdiction of this court, we will hold you liable for any act you do or not do. We are not concerned about where the property was. This led to a huge confusion. And ultimately, when the High Courts of Judicature's Act were created in 1862 and the letters patent was issued for establishing these three high courts, the English legislature thought it's better to correct this anomaly, it's better to correct this confusion. Somehow we must codify the law. So that is why for the first time in 1862, you had something called a letters patent. Now, what is a letters patent? A letters patent is nothing but a declaration made by the king or the queen in England to establish something in writing. So that is a be all and end all of it. It's establishing a new judicature here. I am establishing so and so by a letters patent. 1862 was the first time in India a letters patent was used. I don't see anything before that. So in 1862, the first letters patent came in with clause 12. But there were some problems in the existing letters patent between 1862 and 1865. And the letters patent was amended in 1865. And what you have now in your law books, in your letters patent, was the one amended as on 1865. Now let's see what this amendment is and what this letters patent is. Now, one thing before that is, I told you CPC first came in 1857. Then there was another CPC amendment in 1877, then 1888, and then 1908. 1908 CPC is what you have today. But it went so many metamorphoses before it reached its present stage in 1908. But then there are two interesting provisions in the old CPC as compared to the new CPC, which led to further confusion. And I'll tell you what those two provisions are. Section 5 and Section 33 of the old CPC. Both those sections talk of jurisdiction of civil courts. Now, what is important is the CPC was very clear. It said CPC will apply to all jurisdiction except to courts established by charter. So, once a court is established by charter, CPC will not apply. The three high courts in Madras, Bombay and Calcutta were established by charter in 1862. So, CPC was excluded in its application to these three high courts. So, what should govern those three high courts' jurisdiction is clearly defined under the letters patent. Clause 11 gives original jurisdiction to high courts. Clause 12 says how you should exercise the jurisdiction. Now, the giver of the jurisdiction is Clause 11, no quarrel with that. But coming to Clause 12, there was an issue. The issue was qua suits for land. It said, High Court will exercise jurisdiction over all matters pertaining to land where the suit is for land and where the land is situated within its jurisdiction. So the qualifying words are, I can exercise jurisdiction over your land provided your land is within my jurisdiction. So that was the qualifying word. Previously, no such qualification, lot of confusion. Equity courts, chancery courts, heavy confusion. So for the first time, Clause 12 of the letters patent in 1862 as amended in 1865 said, you shall exercise jurisdiction over land only if the land is within your jurisdiction. Very strictly. But that is not the be all and end all of it. If that was the be all and end all, again, we wouldn't have had any problems at all. So the courts in Madras, the courts in Bombay, the courts in Calcutta started interpreting this suit for land in various ways. Initially, they all started with strict interpretation. Suit for land means to get land. Suit for land is to get possession of land. There are some judgments. Some of them said, no, suit for land means title also added. Some of them said, forget both. If it's incidental to land, even that's a suit for land. So there was a massive confusion on what exactly is a suit for land, especially considering the fact that old CPC also defined jurisdiction. Some judges took the definition of suits pertaining to immovable property under CPC and interpolated it into suits, into Clause 12, which could not have been done at all. Now, we have various judgments of the Bombay High Court, Calcutta High Court, thankfully not the Madras High Court, which has taken the definition of jurisdiction from CPC and imported that into Clause 12 of the letters patent, when the High Court Judicature Act itself says CPC will not apply. So this is the kind of confusion the courts were dealing with as on 1862. Now, after the High Courts of India Act, as I said, came in 1861 and the High Courts of Judicature were established in 1862, Clause 12 of the letters patent reads thus, and I'll read only that portion of the Clause 12 which is relevant for our lecture today. And we do further ordain that the said High Court of Judicature at Madras, in the exercise of its ordinary original civil jurisdiction, shall be empowered to try, receive and determine suits of every description, if in the case of suits for land or other immovable property, such land or property shall be situate. I stop with that. The rest is not necessary for us. So, the determining factor was the situs of the land, the situs of the immovable property, where it is located. Now, thereafter started the tricky aspect of interpretation by the three sets of high courts. Now, it was thankfully common ground in all three high courts that if the purpose of the suit was A, to establish title or determine title, then it's a suit for land. Or if the purpose was to recover possession, then it's a suit for land. That's common ground in all three high courts. No issues with that. But then, what was the problem is Calcutta High Court started this initially. Question there was whether a suit for redeeming a mortgage is a suit for land. Now you all know when I mortgage, my mortgage first of all applies only to immovable properties. It doesn't apply to movable. So when I mortgage my immovable property to create a security for a debt, for a loan which I borrow, I give title deeds of my property to the other person to hold interest. It's a simple mortgage by deposit of title deeds or a registered mortgage. But mortgage pertains to immovable properties. Now, question there was where a person wanted to redeem his mortgage or where a person wanted to extinguish a mortgage. Is that a suit for land? Will it amount to a suit for land? Now, Calcutta High Court initially took a view, a very broad interpretation that anything to do with land is a suit for land. Mortgage suit definitely affects land. What if I don't, suppose I default in payment of debt? What will the creditor do? Creditor will invoke the mortgage, sell the property and take the money and give me the balance if it's there. So it directly touches upon property, therefore the suit for land was the initial view of the Calcutta High Court. Now this view developed and by that time it was, the first view started, in fact, I should tell you, 1865, the year on which the letters patent came in. So this is when the first interpretation started in 1865. The judgment is also reported. But then the law fermented and ultimately, if you see, in 1922, the whole view changed. A division bench of the Calcutta High Court said all judgments rendered till now took a very myopic view. We adopt something called the predominant object test. What is the predominant object of the suit? If the predominant object of the suit is determining title to property, if the predominant object of the suit is to get possession of the property, if the predominant object of the suit is to protect my possession, protect my title, protect my right over property, it's a suit for land. But a mortgage suit is nothing. It just says if you don't pay me, I will sell your property and get my money. It is only money. So it is not a suit for land. So this is when the first confusion started. In 1922, when the Calcutta High Court said division bench, all earlier judgments are wrong. So you see how the interpretation has changed over 60 years. Then comes the Madras High Court. The Madras High Court also adopted the same yardstick as the Calcutta High Court, holding that any and every suit touching land will be a suit for land. But by the time the judges realized their mistake, it was, I would say it was about 1926 again. 1926, the division bench says, all earlier judgments wrong, predominant object test. So don't go by the words used in the plaint, don't go by the prayers in the plaint. You may ask for whatever prayer. Mortgage, yes, sell the property, pay me the money. That's a prayer. It may seem like it's affecting property, but what is the object of the suit? The object of a mortgage suit is money. Object of a mortgage suit is not getting land. I don't become the owner of the mortgaged property. I can only sell that property and get the money, or money is equivalent to extinguish my loan. So the Madras High Court again realized its mistake, moving from a very liberal interpretation to a middle path where they said predominant object test. Now Bombay was another extreme. Bombay, what they said is nothing is a suit for land unless it's possession. Unless you ask for possession, it's not a suit for land. Title, I'm not concerned. Possession is what suit for, F-O-R, they interpret as get land, for land. So initially they started with that interpretation, a complete opposite side of the spectrum, where they said nothing is a suit for land unless it's possession. Then they changed it to title and possession. And then a division bench of the Bombay High Court in 1889 said that mortgage suit is not a suit for land. The same division bench was overturned by a full bench judgment in 1924 saying mortgage is a suit for land. Now, interestingly, when all this happened, the Bombay High Court decided that enough is enough. We need an authoritative pronouncement. Therefore, for probably the first time in the history of Indian judicature, a 7-judge bench sat to decide what is a suit for land. Now, that judgment is very interesting. It is reported in the 7-judges bench is 1927 ILR 29 Bombay, page 498. It's a 7-judge bench, probably for the first time in India. Now, out of these 7 judges, now the question there again was not what is a suit for land. The question there was whether a suit for mortgage is a suit for land. Question there was not whether what is a suit for land is to be decided. Whether a mortgage suit is a suit for land is the only question referred to. But the learned judges considered every aspect, every judgment under the soil till that date, including the Old English judgments, and rendered a virtual thesis tome there. 5 judges of the 7 judges bench took a view that a mortgage suit is not a suit for land. They agreed with the middle view that predominant object test is most important. You may call your suit whatever, you may ask for whatever prayer, but what is your intention for filing that suit? If your intention is to get immovable property, which is not yours, if your intention is to declare your right, title or interest over immovable property, if your intention was to get possession of the immovable property, or if your intention was to protect your possession against third-party encroachments, then it's a suit for land. That is the predominant object test. However, if you're asking for land incidentally, consequentially, it is not a suit for land. So the 7 judges bench held that for a suit to fall under the heading suit for land, the predominant object is a must, falling broadly with the views in the later judgments of Calcutta and the later judgment of Madras. So they all agreed, predominant object test. Now, interestingly, that 7-judge bench, more than the judges who sat and decided that matter, it will be very interesting to note the counsels who appeared there. Now, for one party, Sir Din Shah Mullah. You all must have heard of Mullah's CPC, Mullah's transfer of property, Mullah's Hindu law. That Sir Din Shah Mullah was arguing, and he was instructed by none other than M.C. Setalvad, the first Attorney General for India. Now, on the opposite side was one of the most famous officers in Bombay at that time and even now, Jamshedji Kanga. Now, Jamshedji Kanga's name must ring a bell to all of you because it is from his chamber. His juniors were R.J. Kola, H.M. Sirvai, Nani Palkiwala, F.S. Nariman. We are talking of stalwarts in the Indian judiciary. So, all these people were juniors under Kanga, belong to the chambers of Kanga. So, that was the stature of people who were arguing that 7-judge bench judgment. And as a result came a middle path, that is predominant object test. But then they did not decide the question. The question was whether a suit for mortgage is a suit for land. They held it's not a suit for land, yes. But they needn't have ventured to answer other questions as to whether a suit for specific performance is also a suit for land. Now, that's when Madras High Court came and said in 5-judge bench in 1929, this happened in 1927. 5-judge bench of Madras High Court said, we are not bound by Bombay. Because the question referred to Bombay for 7 judges was whether a mortgage suit is a suit for land. Here the question is whether a suit for specific performance is a suit for land. That's where we come. The Madras High Court 5 judges held again that for it to be a suit for land, you need to be specific about 2 things. One, you must have a prayer which will affect title to the land, which will affect possession to the land, or which will protect your possession. Again, predominant object test was applied, even though lifted from Bombay. I won't say lifted, even though borrowed from Bombay and Calcutta, but that was the general view. So, predominant object test was applied by Madras even for a suit for specific performance, not just a suit for mortgage. Now, while attempting to answer that question, what is also important for you people to note is that the Madras High Court judgment had the benefit of the 7 judges bench of the Bombay High Court. They said this question was not referred to them. Still they answered it. We are not bound by it. But we will give our independent reasoning for whatever we are going to hold. Ultimately, they did hold that predominant object test applies even for a suit for specific performance. Now, why it is very, very important, the Madras High Court judgment is that till that date, till 1929, there was no authoritative pronouncement in India which held that when you file a suit for specific performance of immovable property, is it a suit for land or not? Courts were very loose in their views. Madras High Court for the first time held by a 5 judges bench that suit for specific performance is not a suit for land. For the simple reason that all courts in India have been exercising in personam jurisdiction like the courts of Chancery and the courts of equity. And since it's in personam jurisdiction, I will force you to perform the contract since you have signed it. I am not bothered where the property is situated, because what is a suit for specific performance? I'll put it this way. I'll ask you a question. What do you understand by the word suit for specific performance? What do you ask for in a suit for specific performance? To specifically enforce an agreement. The agreement could be anything. Agreement to transfer movable, agreement to transfer immovable. If it's agreement to transfer movable, no problem with it. But if it's an agreement to transfer immovable, aren't you asking for property from somebody else to yourself? Yes or no? So, when property is situated in Chengalpet, outside Madras High Court's jurisdiction, A is in Madras, B is in Madras, property is in Chengalpet, A agrees to execute a sale deed in favor of B, signs an agreement. B files a suit here in Madras saying, A is here, I am not concerned where the property is, enforce this contract because I am enforcing it against A in person. Same jurisdiction which was being exercised by all courts from England and India till 1929. What is wrong? What the courts were confronted with is, what is the nature of a suit for specific performance? So, to put it in a different way, predominant object, what are you seeking to achieve by filing that suit for specific performance? Now, when A enters into an agreement with B to sell his land wherever it is in India, now what does B do? What does B get? A right to purchase that land. Now, what is the relationship between A and B here? Is B claiming adverse to A? Is B claiming something which is not A's? B simply says, A, I acknowledge your title. I acknowledge that you are the owner. You have signed an agreement with me. Please transfer the property to me. So the courts in Madras, the 1929 judgment held that what is happening in a suit for specific performance is B is suing A in Madras. B says A has signed this agreement. B says execute a sale deed in my favor. There is nothing happening qua immovable property. Transfer of title from one person to another who has agreed to do it. This is not a suit for land because B is not claiming title to the land. What do you mean by claiming title? When do you file a declaration suit? You file a declaration suit when your title is in peril, when your title is questioned, when your title is insecure, when your title is doubtful. So, none of this is attracted in a specific performance suit. B simply says, I acknowledge the fact that A is the owner. I have signed an agreement. Please ask A to execute that agreement. Where is the question of title being gone into here? All right, possession. Next question was, you're asking for possession. Won't that become a suit for specific suit for land? There again, the court very beautifully adjudged the issue by saying, what happened before 1929? Let's see. What was possession in such a suit? Now, the question which the court asked itself was, can you succeed in getting possession if you failed in your suit for specific performance? Your possession is based on an agreement by A to sell to B. You say that execute an agreement in my favor. Ask for possession. Can your possession succeed without the main prayer of specific relief succeeding? If it cannot, then possession is only incidental, ancillary, not the dominant purpose of the suit. That's how the courts in Madras answered it. So, please see the significance of the words dominant purpose. So, first of all, just because you ask for possession, it doesn't become a suit for land. That possession must be an independent relief, a relief for possession by itself. For example, take Article 64 and 65 of the Limitation Act. Suit by a person previously in possession, dispossessed. The simple suit for possession, where the main dominant purpose is get possession back. 65 Article 65, suit by a person against stranger. Adverse possession. If it's within 12 years, I succeed getting it back. If it's beyond 12 years, I lose. So, if it's a suit simpliciter for possession, where the dominant purpose is possession, then it becomes a suit for land. But if a suit is one for enforcement of a contract where possession is incidental, it depends on the main relief, cannot stand independent of the main relief, then even if you ask for possession, it does not become a suit for land. Now, that is the importance of this judgment. Now, unfortunately for us, this judgment has been lost in time. 1925 Madras was followed three times by Calcutta to hold the same, but Madras has forgotten it. In fact, an interesting snippet on this 1929 Madras also, just to kindle your interest. Again, the stature of the people who appeared in that case. Now, the counsel for the appellants were T.M. Krishnaswamy Iyer and Subbaraya Iyer. I'll tell you the importance of those names. And the counsel for the respondent was K.S. Krishnaswamy Iyengar. Now, as far as T.M. Krishnaswamy Iyer is concerned, he was fondly known as Tiruppugal Mani. T.M. Tiruppugal Mani, but that's not his name. He had a penchant for Tiruppugal, and I learned from Justice VRSJ, Ramasubramaniam J, that why that name was given to him by the Kanchi seer, by the Perival of Kanchi. He was bestowed that name, Tiruppugal Mani, because of his penchant to sing that verse. And on 31st of every December, every year, he would take a batch of devotees and go and recite this verse. Tirthani. First morning he would reach Tirthani. Now, that is not very interesting. It's just a pious man doing something, a great lawyer also. But why it became interesting was, he observed that all vakils in Madras and all gumastas in Madras were queuing up before the English judges' house on 31st night to present them something, to gift them something. He thought, what is this happening here? Why are we queuing up before English judges to present them on 31st, when 31st is not even our calendar? It's an English calendar. Why on earth would I subscribe to that? So that's why he started this practice of taking 100-200 people with him to recite the verse in Tirthani. That's how the practice developed, and I'm told it continues even today. Tremendous precedent. Each step on Tiruppugal. Both. Some have learned, some haven't. So that was T.M. Krishnaswamy Iyer for you. And now what has happened is, he became the Chief Justice of Travancore High Court in 1943, and again stepped down, and once again was called, requested, once again became the Chief Justice of Travancore High Court in 1947. And as far as the other two lawyers were concerned, Subbaraya Iyer assisting T.M. Krishnaswamy Iyer. You know who Subbaraya Iyer is. He's a great doyen of the tax bar in Madras. But more importantly, he started 3 institutions which are running even today. Vidya Mandir School, all of you would have heard of it. That is Subbaraya Iyer's. Then Vivekananda College, all of us would have heard of it. And Madras Institute of Technology, MIT. So these 3 institutions were started by Subbaraya Iyer. That is on one side. Now, K.S. Krishnaswamy Iyengar, again a legend, he began his apprenticeship under this great Nugent Grant. He was one of the foremost barristers in Madras, Nugent Grant. Krishnaswamy Iyengar started his career under Nugent Grant, and then he interned and worked as a junior under Justice Murray Coutts-Trotter, who became Chief Justice of Madras. And what is tremendous is, he also helped Justice Murray Coutts-Trotter in bringing out Maine's Hindu Law edition. I forgot the name of the edition, but Krishnaswamy Iyengar helped Murray Coutts-Trotter, CJ, in bringing out an edition of Maine's on Hindu law. So that was the stature of people we are dealing with. And interestingly, Justice Murray Coutts-Trotter was part of the bench deciding 29 Madras. And he had no problems in his own junior appearing before him, because that was the stature of the people then. They didn't bother about these small things. So today, if somebody did that, words will fly. So anyways, so this is what happened in 1929 Madras. Things were progressing smoothly thereafter. And Bombay was again confronted with suit for land, specific performance. Why should we be bound by Madras? Just imagine the confusion. Bombay in 1948, before that Calcutta in 1945, S.R. Das, I read that excerpt to you in the initial stages. S.R. Das said, I am not bound by 7 judges Bombay. I am not bound by 5 judges Madras. I am on my own. So that happened in 45. 48, Justice Chagla, Chief Justice Chagla, he was another doyen of the Bombay Bar who chose to retire as Chief Justice of the Bombay High Court than being elevated to the Supreme Court, like Justice Rajamannar of the Madras High Court, who chose to remain here as Chief Justice and not go to Supreme Court. So we are talking of people of that stature. So in 1948, Justice Chagla and Justice Bhagwati constituted a division bench. This Bhagwati, incidentally, is the father of Justice P.N. Bhagwati, who became a Supreme Court judge in the 80s, was the father of PILs. So that Justice Bhagwati and that Justice Chagla constituted a bench in 48 to decide what is a suit for land. Whether Madras view is binding, whether the 7 judges' view of Bombay was binding on them, because 7 judges was not deciding the question as to what is a suit for specific performance. It was deciding only a question of what is a suit for mortgage. They again applied the dominant purpose test. They again applied the same test applied by Madras. They again said what you pray is irrelevant. What is your main object which you are seeking to achieve? Right. That was done in 48. Matter went on appeal to federal court, because federal court was there till 1950. 50 is when Supreme Court was created. So federal court, incidentally, was the highest court in India, and all appeals against federal court by leave went to the Privy Council. People who could afford it took it to Privy Council. Now, the federal court decided in that most famous judgment, Mulji Jaita. All of you who read what is a suit for land will have to read this judgment, because it's often quoted and misquoted also. So they decided what is a suit for specific performance. Is it a suit for land? Not just specific performance, where the prayer there, see, I'll read the prayer in that suit. Declare that the land belonged to the properties of the plaintiff company and defendants have no interest in the same. This was the prayer. Declare the land belonged to the plaintiff company, defendants had no interest in the same, and defendant be ordered to execute all such documents to perfect the plaintiff's title. In spite of that, the division bench held this is not a suit for land because your prayer is immaterial. What are you seeking? You're not seeking title to the property. You're only saying what was already yours. Recognize it as yours. No title involved. This went to the federal court, and that 48 Bombay again, interesting. For one party, Jamshedji Kanga, and for the other party, MC Setalwad. And the court was assisted by Nushirwan P. Engineer, who was the Advocate General of India. Now, please note the difference. Before, when the federal court was there, Government of India Act 1937, you had an Advocate General of India. After the Supreme Court came in, Advocate General for India. There's a difference. So we had these 3 stalwarts assisting the court then. Matter went to federal court. Now the federal court also was dealing with a plethora of arguments. But Chief Justice Kania is very important. The 5-judge bench went on to hold as follows. I'll just give you a snippet of what they went on to hold. The Chief Justice of the Federal Court approves the Madras view, 1929 5-judges bench view, as the correct view. He says, to confine the meaning of a suit for land to merely obtaining possession is not proper. The widest meaning that will include all suits where anything to do with land, rejected. A suit for land is one where the primary direct object and purpose of which is to obtain possession of or adjudicate title to land. So taking the suit as a whole, all averments in the plaint as a whole, that's something which you have read repeatedly ad nauseum in your law colleges. Read the plaint as a whole. Read all averments as a whole. Don't take out one paragraph and misread it or misquote it. So that's what the Chief Justice of the Federal Court said. Now, he also said one very important thing, that the meaning of suit for land cannot be derived from the CPC, because CPC doesn't apply to chartered high courts. You cannot use the definition of land in CPC, jurisdiction in CPC, to determine what is a suit for land for these 3 high courts. under clause 12 of the letters patent. And the question of jurisdiction under clause 12 cannot be decided independently of equitable principles, which means apply the same jurisdiction which courts in England exercised, equity jurisdiction, chancery jurisdiction, over the person over the person, not the property. If a person is within your jurisdiction, don't bother about the property. As long as you're not asking for title, you're not asking for possession. Directly, independently. Now I told you what's the difference between incidental possession and possession being a main prayer, right? So this is what Chief Justice Kanya said. And he also said one very important phrase, which will become very important for me in my next discussion next week, as to why some of the Madras High Court judgments are totally wrong. And why they have misapplied this judgment totally and come to a conclusion. Ultimately, I heard Justice Anand Venkatesh remark in a speech which he gave some time ago, that he has rendered a judgment which I criticized in my article, and he said it's time for me to overrule it. If I ever sit in a bench, I will overrule it. So, but the problem there was these words used by Chief Justice Kanya were totally missed. It says, the inclusion or absence of a prayer is not decisive of the true nature of a suit. So you can't decide the nature of a suit by the prayer made in the suit. The prayer can be whatever. Today, we file a suit. By the time it comes to court, we see the prayer has been amended by the section or by a section officer in consultation with our junior without our knowledge. So that's what is happening. So when we stand up before the judge, we'll have to rely on this and say, forget the prayer made there. Look at the nature of the suit. As simple as that. But the reason why I'm saying this is practicalities also should be taken into account. The judges in 1950 visualized what we are all going to go through in 50 years or 70 years later and came to a rescue even there. No. Today's judges don't go by prayer. Today's judges don't go by anything. So this is what happened. Now, the federal court, as I said, is a 5-judge court. So one is Justice Kanya's judgment. The other is Justice Patanjali Shastri's judgment from our court. So there also, he culls out, he agrees with Justice Kanya predominantly, but each judge has to have his own view written, right? Ultimately, how will you be known as a judge unless you write judgments? So, where he says, where the effect of a judgment is only in the nature or command of a prohibition against the defendant personal jurisdiction, it is not a suit for land. Then, every suit relating to land is not a suit for land. Predominant test is important. And he says, qua specific relief for immovable property, the plaintiff concedes to the title of the defendant. He claims under the defendant, not adverse to the defendant. Therefore, no question of title there. He claims possession as a consequence of the sale deed. Therefore, no question of title, possession, not a suit for land. So that is the importance of these two judgments, 7-judge Bombay and then 3 judgments, 7-judge Bombay 27, 5-judge Madras 29, 1950 federal court 5 judges. Of course, 2 judges in the federal court disagreed. And why they disagreed, the judgment will say. But what is more important is, in 2003, the Supreme Court, in Atcon's case, I'll come to it the next lecture. In 2003, the Supreme Court quotes the dissenting judgments and say that's the good law, without realizing it's a dissenting judgment. They quote from the dissenting judgment in Mulji Jaita, 5 judges bench. They leave out Chief Justice Kanya. They leave out Patanjali Shastri. They leave out another puzzle. The other judge I forget. Probably, yeah. So what they did was quote from the minority view and said that is the judgment of Mulji Jaita 50, without realizing that's a minority view. But then we'll come to it later. So sum total of the arguments is even 50 federal court comes to a conclusion that in personam jurisdiction is what is important for deciding whether a suit is for land or not. So when you're exercising in personam jurisdiction, you're not concerned where the property is situated. Now, I was discussing this with Justice Ram Subramaniam. He said, the reason behind this in personam jurisdiction, I'll tell you, these English fellows were selfish. They wanted to protect their property. They wanted to protect their interest. They created this jurisdiction. I don't agree with him, but that's his view. But the beauty of it is, it has been the view since 1704, when the first judgments were reported, till 1950, when it stood confirmed by Moolji Jayata, 5-judge bench of the Federal Court. Now, after this Moolji Jayata, there were 2 judgments of the Calcutta High Court which followed Moolji Jayata, especially Patanjali Shastri's judgment, and said, whether you ask for possession or not is immaterial. Again, they say, possession in a suit for specific performance is merely incidental because it cannot stand on its own legs. So if you cannot ask for possession without the first prayer of specific performance, forget possession. It's incidental. But if you ask for possession independent of specific performance, then it becomes a suit for land. And this distinction till 1950, adopted in Calcutta till 1964, again lost in time. The reason why I am saying this is, all this went for a toss in 1963. Can anybody guess why this 1963 is a red herring here? We are talking of specific relief. Anybody's guess? And the Bar Act, everything in 1963 la or Bar Act vandirukum. Specific Relief Act. Correct. So Specific Relief Act was enacted, came into force in 1963. We had an 1877 Specific Relief Act, almost akin to the present, almost, barring a few sections, barring a few additions, barring a few deletions. And I'll tell you why those are not even important. But while interpreting the 1877 Act, we have 7 high courts in India. So apart from Madras, Bombay, Calcutta, we had Patna, we had Nagpur, we had Mysore, and one more. I don't remember. Sindh, probably. So all those high courts said, under the 1877 Act, possession is only incidental. And all these judgments were obviously to the knowledge of the great judges sitting in 1950 in the Federal Court. They know what the law is. And they adopted that saying, possession is incidental in a suit for specific performance. Now, all this whole field of law from 1877 to 1950, before the 1963 Act came into force, held one thing in common. And that one thing is, when you ask for a prayer, determine what the suit is based on the predominant object of the plaintiff. The purpose sought to be achieved by the plaintiff, not by his prayer. If you pray for specific performance, first check whether you are accepting title to the defendant. Check whether you are claiming possession independently. If these two don't happen, it is not a suit for land. Possession ought to be claimed. Now, I'll give you an example. Suppose A buys property from B. A puts B in possession. Agreement. Defaults in the agreement. Suppose the sale consideration is 10 lakhs. He takes 5 lakhs, puts B in possession. For the balance 5 lakhs, B is ready, A is not ready. So B sues for specific performance. Does he need to ask for possession? Answer is no, because he's already in possession. Take another example where A sells his property to B. There's a tenant in occupation. B says, I'll buy the property from you, put me in possession. Is he claiming adverse to the plaintiff? No. He is only claiming possession as a consequence of the sale deed to be executed by A in his favor. Take another case where there is a partition between co-owners. Partition happens, or doesn't happen. One co-owner sells his undivided share to another stranger. Those things happen very regularly. A co-owner selling their undivided share to a stranger. What can the stranger do? After getting that sale deed, he can't ask for possession directly. He has to sue for partition and separate possession of his share. That becomes a suit for land. Because your main aim is to get possession of that portion of the property which the court decides. So these are the examples which were there from 1700, from 1800, 1900. All courts were aware of this. All courts adopted this and said, listen, we are not concerned with possession ex facie, prima facie. If it is an incidental prayer, don't bother with it. And this is what 27 Bombay held. This is what 29 Madras held. This is what 50 Federal Court held.